Hello everyone, I am Kavya Priya from 3rd BCom A. My topic is Special Types of Customers in Banks from the subject Banking Law and Commercial Practice. There are totally 11 special types of customers in banks. The first one is minors. A minor is a person who has not completed 18 years of age. In case a guardian of his person or property is appointed by a court of law before he completes his 18 years, the period of minority is extended to the completion of 21 years. As per Section 11 of the Contract Act, a minor is incompetent to contract, but Section 26 of the Negotiable Instrument Act allows a minor to draw, endorse, deliver, and negotiate a negotiable instrument. The next category is lunatics. Persons of unsound and unstable mind are known as lunatics. An account in the name of a person who is a lunatic should not be opened by the bank. But in case, without the knowledge that the person is lunatic, a banker has discounted a bill duly written, accepted, or endorsed by a lunatic, he can realize the money due on the same from such person except in the circumstances where it is proved that the banker was aware of the lunacy of the person concerned at the time he discounted the bill. The next category is illiterate persons. An illiterate person means a person who can't sign his name. While opening of an account of such a person is unavoidable, the banker should obtain left thumb impression on the account opening form and specimen signature card in the presence of an authorized bank official. Details of identification marks should be noticed on the account opening form and specimen signature card. At least 2 copies of photograph duly attested by any account holder or authorized bank official. The next category is married woman. A married woman can enter into contract and bind her personal estate. The present banking practice shows that married women are no longer a special case. A married woman, being an independent person, is legally competent to enter into a contract, and thus banks can safely open account in her name after observing usual safeguards. A banker may therefore open an account in the name of a married woman. Executors and administrators. An executor is a person named in the will of a deceased person to administer his estate after his death. The executor derives title and authority from the will for the purpose of administration of the property of the deceased. But before acting upon the will, he must obtain a probate from the competent court of law. An administrator is a person appointed by the court to wind up the estate of the deceased when a person dies intestate. That is, the person dies without leaving behind a will. The administration is appointed when testator has not mentioned the name of executor in the will, or executor named in the will dies before the testator or refuses to act as an executor. The executors and administrators can open account in banks according to some circumstances. The next category is trustees. A trustee is a person or firm that holds and administers property or assets for the benefits of a third party. A trustee may be appointed for a wide variety of purposes, such as in the case of bankruptcy, for a charity, for a trust fund, or for certain types of retirement plans or pensions. A banker must be cautious in opening or operating a trust account, as the trustees are responsible for public money. The next one is joint accounts. Joint account means account of 2 or more persons who are not partners. The next category is partnership firm. A firm's account should always be opened in the name of firm and not in the name or names of the individual partner or partners, because the partner does not have implied authority to open a bank account on behalf of the firm in his own name. The next category is joint stock companies. A joint stock company is an artificial person and it has a separate legal entity. So, a bank account may be opened on its own name. A joint stock company may either be a private limited company or a public limited company. The next one is societies and other non-trading institutions. The society, be it a club, school, hospital, or any institution, must be registered as a corporate body. Societies, unless registered, are not recognized by the law and have no contracting powers. The last one is customers' attorneys. A person may, by a written and a stamped document, appoint a person as his attorney to deal on his behalf with third parties. This power may be general to act in more than one transaction or special to act in a single transaction. The power of attorney can authorize a person to sign checks, that is, operate the account on behalf of the customer. And at last, the conclusion is the customers of banks consist of millions of private individuals, hundreds of thousands of small businesses, some formed as private limited companies, the majority being sole traders or partnerships. Some persons like the minors, drunkards, lunatics, and insolvent, not competent to enter into valid contracts. Some other persons like trustees, agents, executors, etc., who act on behalf of others, have limitations on their powers, thus requiring an extra care to ensure that their accounts are conducted in accordance with the provisions of their respective characters. Thank you.